Hello, everyone, and welcome. We see more participants joining. I think we will give it maybe just one more minute. And in the interim, invite you to introduce yourself in the chat box if you haven't already, please. Your name, affiliation, and email address, ideally. And we also wanted to share that at the end of day 2, as there was at the end of day 1, we have a Mentimeter survey for your feedback, and we would really welcome that and encourage you to take the couple of minutes at the end of the meeting to complete the survey for us. Okay, I think in the interest of time, we'll go ahead and get started with day 2 of Justice Sector Measurement Talks. Welcoming everyone who's joining us from around the globe. I see, we're very pleased to have you here. For those of us who didn't join us yesterday, I'm Mary Margaret Deneen, the Director of the Global Programs Division at ABA ROLI and also the Just Track Program Director. And it is my pleasure to welcome you and also to welcome and introduce Peggy Ochandarena, who is going to be our moderator for today. Very pleased to have Peggy, who is a Senior Advisor with the Development Research, Innovation, Data, and Outreach team at Monix. So over to you, Peggy.
Thank you, Mary Margaret, and you all can call me Peggy. Nobody has to learn my last name. So welcome back to those of you who were here yesterday. And if you weren't here yesterday, you missed some great presentations. And John Gates is going to edit the recording done yesterday, and it will be available in a week or so on the portal, on the Knowledge portal, as will today's. And the slide presentations, the PowerPoints, will also be available on the Knowledge portal. So yesterday we heard from more than three great presenters. I think there were 5. So we heard about 3 great tools for measuring justice. We had Dr. Pim Albers and Jay Tokol of ABA ROLI walk us through their new practice note on measuring success in judicial reform initiatives. It's a very practical, very hands-on guide at all different levels of the program implementation stages. They gleaned the wisdom of the crowd, and by that I mean many of you on this call, to compile tips and learning from years of development experience. It's also a living document, so if you see things you would like added or new tools come out, that tool will be updated. We heard from Dan Hall, who introduced us to the 3rd edition of the International Framework for Court Excellence, another very useful, very hands-on tool that I have used in some of the work I've done. I like it because it's a self-assessment model, which is great for sustainability. Our counterparts in our countries can use it on a continual, regular basis to decide where they want to strengthen next. And then we heard from both Melina and Stephanie from INL Columbia, who really pushed us to think about how to measure training beyond, did people like it? Did they learn something? By applying the Kirkpatrick model and thinking about whether people have applied what they've learned in their jobs, and has that made a difference to how job performance is done, how services are delivered. So really getting to the results and the outcomes of those trainings. So we have stellar presenters lined up again for today. I think you will learn a lot from them. It's a different type of discussion. It's not necessarily about 3 tools crafted for us, but it's about harnessing data to strengthen justice. And I just will let you know that some of the folks in the audience today are dialing in. So if there are key points on slides, presenters, you might want to talk them through verbally instead of depending on visuals. So we're going to follow the same format as yesterday, 10 minutes of presentation, 15 minutes of Q&A. You'll see a hand icon at the bottom of your screen. You can click that, and put a question out there. You can put one in the chat. And I know the presenters are happy to have dialogue. So you don't have to have a question. You can have a comment. You can tell us about your experience. So feel free to talk with us. And I'm not the timekeeper, but I am the appointed time police. So if I cut you off, I apologize in advance. And on that note, Diane Robinson of the National Center for State Courts is going to start us off. She'll be talking to us about the National Open Court Data Standards and the Court Statistics Project. Diane is a Senior Court Research Associate. Thank you, Diane.
Thank you, Peggy. I appreciate that, and I'm thrilled to be here today and thrilled to be here with all of you talking about one of my absolute favorite topics, which is data. Yesterday we heard from some of our colleagues about evaluation. Pim Albers talked about effective and efficient courts, talked about accountability and transparency, which are critically important for our courts. We heard about self-assessment, had some questions about comparisons between courts, and that's really some of what I want to talk about today, because for comparisons between courts to be meaningful, they have to be based on some data standards. Those of us who work in the court world and work with data are often, we complain that our data are misused and misinterpreted. And my response to that is because we make it hard to understand. Sometimes the same term can mean something different just a few miles or a few kilometers away because we use terms differently. So a couple of the projects that we work on at the National Center for State Courts are all about creating and implementing, helping courts to implement data standards. There are two projects I really want to talk about today. One is the Court Statistics Project, and the other is the National Open Court Data Standards Project. The Court Statistics Project has been going on for more than 40 years. So Dan Hall said yesterday that evaluation is a marathon, not a sprint. I will tell you that implementing data standards is also a marathon and not a sprint. We've been working on this for more than 40 years and still have challenges for the Court Statistics Project. The Court Statistics Project is all about collecting and sharing aggregate data from the 50 states, District of Columbia, Puerto Rico, Guam, and the Northern Mariana Islands. The goal is to have a national perspective on what's happening in state courts within the United States. And I've provided the website there. It's www.courtstatistics.org. The National Open Court Data Standards Project, or NODS, is a much newer project developed just in the last few years. It's consistent with the Court Statistics Project, but the focus is really on case level data as opposed to aggregate data. So the goals are to lower the burden of data requests to court systems, because our court systems receive hundreds and hundreds of data requests. So to lower the burden by having some standard definitions and standard requests, and also to reduce the misinterpretation of court data. The website for that one is www.ncsc.org/NODS. Next slide, please. I want to show you an example from our Court Statistics Project. And for those of you who are just on the phone, this is an image from our dashboard that shows relative case filings and caseloads around the country. And we provide these by state, and our dashboard allows people to drill down by criminal, civil, family, juvenile dependency. There are a lot of different ways you can look at the data. You can look at filings, you can look at dispositions. But again, for any of this to be meaningful, it has to be based on data standards. And so one of the things that we do, next slide, switch to the next slide, please, is we publish help for courts and provide technical assistance to implement these data standards. With the Court Statistics Project, we have a state court guide to statistical reporting. We also have a data governance policy guide to help encourage courts to have meaningful data governance. With the NODS project, we have a data element spreadsheet, a leadership guide, a user's guide, technical notes, and technical data models. And again, this is all to help courts to be able to implement these. State court systems, as those of you who are familiar with state courts in the United States, state courts are operate very differently because they are based on state law. So there's a lot of variation. The idea of NODS is not for everyone to change to fit some standard, but to provide a way to map to common standards. So regardless of how terminology is used locally, to map to a common standard. So next slide, please. To give an example of this, I just took just one tiny section of the NODS data elements to give you an idea of the kind of granularity we're talking about. It provides the data element and a very specific definition of what is meant by that data element, and then a list of values that would be appropriate for that. So, for example, case initial filing date, that may seem like a very straightforward thing, but courts sometimes define that differently. So we have the definition that it's the filing date of the original petition or complaint, and the value would be a date. So the idea, again, here is not that courts will change necessarily how they're collecting data, but give them a common mapping so that we're talking about meaningful comparisons. We're talking about apples to apples. The next slide, please. To give an example of this, one of the court tools that we often use is the clearance rate. It's simply the number of outgoing cases divided by the number of incoming cases. But again, for this to be meaningful, we have to have common understanding, a common definition of what is an outgoing case and what is an incoming case. So as part of the Court Tools project, we lay that out and explain exactly what that clearance rate means. Next slide, please. And courts take this, in many courts, I pulled one just kind of at random. This is Cuyahoga County in Ohio, and they publish their clearance rate on criminal matters. Some courts, I was looking at the El Paso court in Texas yesterday, and they publish it by judge, giving that clearance rate and comparing it to their standards. So very public, very transparent, accountable for what they're doing. Next slide, please. Another court tool that we use is time to disposition. This again is something that is very useful in looking at how courts are operating. Being transparent about this information gives a lot of information about what courts are doing. Again, we give the definition, the percentage of cases disposed or otherwise resolved within established timeframes, and even give examples of these are the cases that you count and these are the cases that you don't count. And this is just an image of a timeline showing cases starting and ending and which ones you would include for this measure. In the next slide. We have used this time to disposition in a really exciting project done by one of my colleagues, Brian Ostrom, the Effective Criminal Case Management Project, where we pulled specific case level data from criminal courts around the country and looked at the percentage of felony cases resolved at various time standards. And what we found is courts that operate more timely, that those were courts that had that resolved the vast majority of their cases, 90 to 100% of their cases within 1 year. The mid-range courts were the courts had that 80 to 90% resolved in a year. And then the courts that were less timely that were only hitting 70 to 80%. Again, for this kind of measurement to be useful, for it to be interesting, for us to be able to take action, identify what really makes for a more effective court, we have to have those common standards and those common definitions. Next slide, please. So without standards, data reports are really just numerical anecdotes. If we are not using the same terms, if we're not using the same definitions, if we are not able to actually compare courts and use common terms and common terms, common definitions, have those standards, we're not able to do meaningful comparisons. It's essential to be able to have good transparency, good accountability, and to make sure that what we're saying is really what we mean. So with that, I'd like to open it up to any discussion or conversation.
Thank you so much, Diane. And while we're waiting, again, please raise your hand if you have a question or a comment for Diane. We would love to hear from you, or feel free to put something in the chat. And maybe I'll kick us off by asking you, are these open court data standards applicable in our context in developing country judicial systems?
Absolutely, I think that they are. The data standards, and I would encourage anyone who's interested in them, it's at www.ncsc.org/nods. I'm actually going to put that in the chat so that it's easy for everyone to see. There are the data standards have hundreds of data elements. And so what we're doing with state courts, and what I would also encourage anyone who's interested in looking at this in the international context, is to look at those and determine which ones are relevant. One thing we don't talk about very much is the fact that what data we choose to collect is a values choice. It's a choice about what's important to us. When I'm working with states on implementing the National Open Court Data Standards, I encourage them to go through the data standards and to determine, first of all, which ones they already collect, which ones they have. There are many that are very straightforward. I ask them if those they do collect, is it collected in a form that is actually usable? So for example, is it collected in a data field that you can actually pull, or is it hidden in a minute order or a text field or something that makes it much more difficult to obtain? So looking at that, also looking at whether the data are reliable, if they are good quality data. Then the next question is really important: is this data that's important for your court to collect? Because there are some data elements in the National Open Court Data Standards that are definitely aspirational, and some courts are everyone has limited time and resources. We don't expect that any court is going to collect every single data element. So making those decisions about which ones are most important operationally for their own courts.
Thank you. Pim, you have a question. Dr. Albers.
Yeah, I have a question about the reliability of the data, because I can imagine that you showed some comparison between courts that are lesser good performing in, let's say, felony cases. Others are better. Have you observed in your, let's say, project on data collection at state level courts any form of manipulation of data that courts want to present themselves better than others? And the other thing is that, of course, this initiative at the national level requires the availability of data. And in developing countries, that is just the challenge. So how easy it will be to, let's say, import your approach also in developing countries, given the fact that not always the data is available, or that, of course, when the data are available, try to manipulate it.
Yeah, so two really good questions. I appreciate you asking those. On data manipulation, I will, to me, that always goes to questions of incentives. And so if funding, for example, is based on the number of filings, then there might be an incentive then to cook the books a bit to increase the funding, and there's no question about that. Each of our state court systems have people called data specialists whose job it really is to ensure that the data that's being reported is correct and that is accurate. There are also checks and balances in terms of other organizations. For example, when you're talking about criminal data, if you're looking at the cases that the courts are processing, the numbers from the prosecutor's office should be similar. And so there are some checks and balances available. I will say that I have not seen or heard of large scale examples of manipulation of data. I've seen more, tweaking where, I'll just give you an example. Let's say a criminal case involves 3 charges, and that they're filed as 3 different cases to increase the numbers as opposed to 1 case with 3 charges. And so there are, before I worked at the national Sonoma State Courts, I worked for a state court system, and we did routine checks for things like that. And we would go through and correct that data to make corrections for that. So kind of knowing where those potential weak spots are and watching for them, I think is important. In terms of the applicability in developing countries, I absolutely think this is applicable. And I would argue that agreeing on data standards when you are in early stages of collecting data is actually the perfect time to do it, because it's easier to start out with good data collection than it is sometimes to go in afterwards and try to create more consistency. So again, I would not expect anyone to look at, for example, the National Open Court Data Standards and implement them wholesale. They are very aspirational, but I think it can be a good starting point for looking at them and deciding what is important and relevant in the local context and making that decision. But again, I think that when you're just really starting to do data collection, really just starting to move from having all of the data just in the court orders or in the court forms and starting to collect that in a different format, that is actually the perfect time to be talking about data standards.
Very useful, Diane. Thank you. Happy to take other questions. We've got one from Waqas Masood. Who provides the data? Is there a desk established? Who collects and shares? And what is the cost associated with this effort?
Okay, so it is within the context of the state courts in the United States, it is difficult to give a single answer to that because every state does things differently, and sometimes, and within many of our states, sometimes every county does things differently, and so there's not a single answer to that. It is common in state courts in the United States to have a clerk's office, and in most places, it's the clerk's office that is ultimately responsible for collecting the data. But it really has to be a team effort. With if there's the clerk, the court, the judge, any staff members the judge may have, if they have any, together to do that information. What is most common is that when a case is initially filed, the person filing the case provides the essential data points about the case. Most typically to the clerk's office, and then it's the clerk's office that typically has the responsibility for doing that. In terms of the cost associated with this effort, I cannot give you a figure for how much it costs to collect the data. It is certainly a time intensive, and there's no doubt that collecting good quality data requires significant resources. If in situations where resources are limited, my recommendation would be, again, focus on the most essential data elements. What are the things that we need for base level transparency and accountability, and focus on collecting those. I said I wouldn't start with hundreds of data elements. I would start out with some really key core data elements.
So you mentioned transparency, Diane. I've run into, and I'm sure others have run into, courts who feel like they want to protect their data. They want to hold it close to their chest. Sometimes in the name of judicial independence, they don't want anybody interfering in their business. So how can we address this balance between protecting data and data privacy and openness and transparency with data?
Well, Peggy, this has been a huge cultural shift in courts in the United States over the last say 10 to 20 years. We did have a tradition and a history of judges being in ivory towers, and for those of you who aren't familiar with that term, it means really they're responsible only to themselves, that they are somehow above or separate from the general public, on some rarefied plane. And that has really changed. One thing that courts have really realized is if they are not transparent, the data will get out anyway. And it is much more productive for courts to be on the front side of that and presenting the data with context and with information, that it is better. So many of our data systems are now, a lot of data is available on the internet, and that's considered to be an important public service. But that also means people are constantly skimming that data and using it for all kinds of different purposes. So there's really no, I frequently tell judges that ship has sailed. Court information is public, is expected to be public. At least in the United States, and that if they are not ahead of the game in terms of sharing that information, it's more likely to hurt them. One area where that's been a big issue in the last couple of years has been with race data. So there have been a lot of requests, and historically, some of our courts have been very hesitant to collect data on the race and ethnicity of individuals in the courts because they've been afraid of how that data might be used. We are pushing very strongly that it's your responsibility to collect and analyze that data, and if in fact there are problems, then it's your responsibility to address them. But not collecting it and hiding it is not a way to address the problems. Now, the other piece of that, Peggy, that I want to hit, if I can just take another second on that, is the question of privacy. individuals who are in the court system, some of them, some information under our state laws is absolutely public. Criminal information is a good example of that. But other information, particularly involving juveniles, is not. And so with this push to have more transparent data, more accountable data, it's also incredibly important for courts to put in protections to make sure that information that is truly private remains so. And that's a whole nother topic of conversation, but it's one that courts need to be attentive to from the beginning of setting data collection strategy or establishing data governance policy.
Thank you, Diane. We have 2 questions come up. Melissa Ramirez, you've raised your hand. Melissa.
Thank you. I'm working with the ABA's Rule of Law initiative in Latin America. So I'm really new to this, but a lot of the data that we're really interested in is obviously abroad. And I know you mentioned that you may collect some international data. So I guess I'm just wondering if you could provide me to maybe links of where I could get that data, because we're really interested in looking at like number of investigations and prosecutions related to wildlife trafficking or trafficking in persons. And so it'd be really interesting to be able to see the sort of data that we collect, that's being collected abroad by different governments.
Thanks, Melissa. That's a great question. And we don't, as part of our court statistics project, it is strictly limited to the United States and territories. So we don't have information. The only way we would collect information like that would be if we were doing a specific project. So it really does become a question when you're looking for data of really working your way backwards to see who has access to that data to start with, where does that data originate, and starting there. And again, anytime you're doing data requests, it's very important to be very specific about what you're asking for, and if something's not clear, to ask for clarification and definitions. Ideally, every data set should have a data dictionary that explains exactly what each term means. Those are often lacking. And so it's important to develop that and ask a lot of questions about data to make sure that you know exactly what you have. But I don't have a great answer for you in terms of one place to go to get the kind of data that you're looking for.
I guess my follow-up question is, you mentioned that it could take years to gather really good data, and it's been this very long-term project. And so I'm wondering if you have some sort of reports that document the ways in which you all went about strengthening the data collection.
Absolutely, I'm happy to share those with you. On our court statistics page, you can see the current version of our and on the NODS page as well, you can see our documents where we explain definitions. If you're interested, I'd be happy to show you the prior versions of that that led us to where we are today.
Thank you.
Thank you. And we have another question, whether this data is only applicable in the US or what SEA countries. I'm guessing that means Southeast Asia, but if I'm wrong, please correct me.
It's true, Southeast Asia countries, that's what I mean.
Okay.
Southeast Asian countries, okay, great, thank you. You know, these data standards were written specifically for state courts within the United States. Where I think that they might be helpful in other regions of the world would be in if you don't have data standards, they could serve as a starting point, as a jumping off point to think about data collection. But again, I don't necessarily think what is important or relevant to collect in the United States is necessarily relevant or important to collect in Southeast Asia. Again, we get into some questions of culture and priorities that would need to be looked at. I offer NODS, the National Open Court Data Standards, not necessarily as something that is applicable worldwide, but as a model and as a way to move forward in having standardized data in your own region or your own country.
Okay. Diane, thank you so much. This has been great, very interesting and very useful for us. I just want to note that Pim has put a couple links in the chat about where you can find criminal statistics for Europe, as well as some other comparative statistics. So we appreciate your presentation and your openness in sharing all these great tools with us and how to develop them, and encourage people to use those links to the NCSC website to learn more about data standards. And so with that, we're going to move on to our next presentation, and we will be welcoming Alejandro Ponce from the World Justice Project, where we're going to learn more about the data that contributes to the Rule of Law Index. Thank you so much, Alejandro, for joining us today, and you're up.
Thank you, Peggy. Thank you. Thank you for the invitation. So next slide, please. Okay, so we know that there are, in our work, we face multiple types of data, and there are many ways to organize the data. So this can be either qualitative or quantitative data, expert data, administrative data, how we measure it. It can be perception, experiences, administrative records, level of aggregation, representativeness. There are many different ways to classify the data that we use every day. And in the justice data ecosystems, we know that those data ecosystems in many parts of the world are complex and in many cases underdeveloped. So we need to tackle with those. So today I'm going to talk about three types of data that we often find in our work: composite indicators on indices, the surveys to the general public, and surveys to users. And very briefly explain just some of the benefits of those using the experiences of the work that we have done. Next slide, please. Next. So the first one is the Rule of Law Index, that some of you may be familiar with this. The index is a multidimensional tool. It's an effort to collect indicators on different aspects of the rule of law. So the index has about 42 indicators that are aggregated in 8 categories that range from security, corruption, accountability, civil justice, criminal justice. Next slide, please. In order to collect this information, we interview in every country that it's indexed 1,000 people of the general public and experts, attorneys in civil law, criminal law, labor law, or public health. And we ask their experiences and perceptions about their day-to-day work, their experiences and perceptions about how they interact with the government and different circumstances that then we map into the system, into the index. So for the 2020 edition, we had 128 countries, 130,000 household interviews, 4,000 experts, and over 500 variables. Next slide, please. So the way that we present information, we put together all the information that we collect from these 2 data sources in each one of the countries. We map it into the different indicators, and then we aggregate them. We present them in terms of scores and rankings. First for the rule of law, next slide. And also for some of the countries, for some of the sub-indicators. We also present information in terms of country profiles. So we know that sometimes people are interested not so much in comparisons, but in looking at the country in particular. And we present information for each one of the indicators that we have in terms of country profiles. The next one, please. We also, there is another way to present this information. The index is one way, but we have above all 500 questions. So for some countries, we have produced some reports in which we organize the information differently. To give you an example, criminal justice institutions, when we think about criminal justice in terms of the index, we present it in terms of outcomes of the criminal justice system. For example, whether it's timely or effective. But there are other ways to organize this information. For example, in terms of the actors of the system, how prosecutors are performing on courts, criminal investigators. And that's one way in which we can reorganize the information and present the information in a more disaggregated way. So the index provides 2, just first disaggregate cut, but also the more disaggregated information. Next slide, please. Who uses the data? As you can imagine, this high-level data, it's useful for countries and bilateral agencies, USAID, USAID implementers, the EU, etc., multinational organizations that use it mainly to compare and benchmark countries, the media that are useful to, the data is useful to place some of the issues that they may talk about in perspective, and finally businesses, including rating agencies, to essentially understand the business environment in which they are operating in different countries. Next slide, please. So another example, just digging deeper into this, is a work that we have been doing in Mexico, in which rather than showing one data point for a country, we go deeper and we present indicators at the subnational level, at the state level. Next slide. And this obviously has been picked up more by the media because just there is much more information there. Next slide. And importantly, it has been an interesting tool to engage with governments. So many governments have adopted these, have adopted indicators as part of the benchmarks and the targets that they have in their national development plans. Those are the states that the states highlight that the states are adopting them, or using them in just to frame some of the discussions that they have. Next one. So very broadly speaking, so the strength of the indicators is that they provide a common framework, a big picture. They are comparable across countries, and they are useful for benchmarking, particularly for those people working across countries. So the weaknesses is that they really provide a big picture. So these are useful if we are going to do a dig deep in the country. These are useful for starting to place the country in comparison to other countries, but it's more difficult to use them for program evaluations, and in some cases, they may be more difficult to interpret. Next slide. So now another type of data is survey data and data from the general population. So I'm going to present an example of data that we collected as part of the Rule of Law Index, but that we presented in a different way. Next one. So in 2007 and 2018, as part of the general population surveys, we included questions that related on how people, for example, experience problems and what they do when they experience justiciable problems. What are the type of help that they use? What is the information that they look for, and what they do with the problem? Do they go with the court? Do they go to a mediator, or do they do anything in the first place? So this exercise actually serves as the methodological basis for the 16.3.3 indicator. Next slide. This allows to see, for example, something as how ubiquitous are the unmet justice needs. And by that, just we can look at a range of countries, and we see that on average, for example, 49% of people may experience a problem and may not necessarily find ways to solve it. Next one. But it allows to see as well the experience, as I was saying, of people, just whenever they experience a problem, what they do. This is the global perspective, whether they actually look for information, what they do actually, were they able to get help, the status of the problem, and so on. And importantly, just the hardship that they may experience as a result of the problem. Next slide. So what this allows is to look at perceptions and experiences, and importantly, just experiences outside of the system. These are situations before we get them into the court system. So the weakness, obviously, that it's difficult to measure experiences within the system, but these are very useful data, for example, for understanding demand or understanding what happens to the people that do not have access, for example, to the system. Where do they go, and so on. Next one. The final example is survey data from users. Next. And this is an exercise that we did with the statistical agency in Mexico to collect information about inmates. Next one. So this information allows to ask questions not only about their life in prison, but about the experiences that they have had when they went through the process, their cases. So information that is often not recorded in cases. For example, what we're seeing in the picture is questions about whether people pay attention during whether the judge pay attention during the case, or questions about their processes, whether people were mistreated, and so on. And interestingly, given the way that this was built, it allows to make comparisons across reforms. So this was an interesting exercise to measure, for example, in the case of Mexico, transitions from inquisitorial to accusatorial system, and see how the system changed actually from the perspective of those who have actually gone through the system. And we see a lot of change in a lot of different areas in the system. Next one. It was useful to show support for the reform just with statistics, but also to measure and to advocate for numbers that are often hidden. For example, as I was mentioning, information about mistreatment and torture, just a large number of people just that report that they were mistreated during detention and interrogations and so on. We were able to show it with this information. Next one. So finally, then the system, it's useful to show perceptions, experiences within the system. It complements information from case management systems, but obviously it's a limited resource for experiences outside the system, and obviously some information is difficult to capture. So all these sources complement each other, and it's useful obviously to use them in tandem. Next one. Summary, composite indicators, common framework comparison, big picture, service to the general public, useful to see the perspective outside of the system, service to users, useful to see the perception within the system. Thank you very much.
Thank you, Alejandro. That's super interesting. Always great to hear about how that index is put together. We're open for questions if anyone has a question or a comment. Pim, go right ahead. Thank you.
Well, thank you very much. And also, of course, it's always interesting to hear from the World Justice Project. What I was wondering about is that this rule of law index indicators and the results of the measurement is mainly based on perceptions and opinions. And I can imagine that there might be a difference between opinions and the people that are actually came into contact with the justice system, for example. Did you try, or are there attempts, let's say, to combine these various sources of information to make the rule of law index more solid and rigid? And secondly, based on the perceptions of this World Justice Project studies, I can imagine that there might be cultural differences of how people in certain countries perceive, let's say, the level of the rule of law, that it can be interpreted in one country completely different than in another country, but they are being ranked with each other in an international way. So I'm curious how you are trying to resolve this.
Yeah, thank you, Pim. Very good question, actually. So let me try to address you asked two questions. The first question was about just using the experiences from the people who have actually interacted with the system. So in the case of the index, what we did for indicators that are related to the performance of the justice system, we mainly use the perceptions from attorneys. So that's the intention indeed of using the perceptions or asking experts and attorneys in different areas of the law is precisely to understand these perspectives. We know that very few people may interact in their lives with the criminal justice system. If we ask the general public, very few people will know. The civil justice system, probably a little bit more, but it's still just a limited number. And that's why we ask just attorneys who in principle are interacting with the system constantly. The questions that we ask to them are questions about day-to-day operations of the systems. So it's not about like the experts' opinions. It's the way that the questions are framed are more about just their experiences with the recent cases, just perception questions, as you pointed out. But the intention is really just to use them as agents of the public who interact with the system frequently. Now, obviously, this has limitations, and that's why I presented the other two data sources. No, because we know that this is useful for providing table one, just understanding more or less what the big picture is. But if we really want to understand what's going on in the system, we need to use other data sources or the data tools, and that's why that was part of the rationale, for example, of building the model on civil justice, is to try to start understanding those perspectives from those people who actually go through the system. Still, it's probably not the best source, for example, just the general public to understand the experiences of cases through the system, because in many cases we're comparing pears and apples. Just cases may be different, and it's difficult to actually look at the same case if it goes, for example, through different journeys. But it's useful for understanding the perceptions and understanding demand as well, just what people are actually doing just when they don't go to the system. Now, the other question that you have about comparability. So that's an important point. In many cases, what we try to do is to use anchors to try to put what the standard is, let's say, just by good criminal justice, we understand this. And that can help to make the comparisons more reliable. In other cases, we try to just be as specific as possible, but I understand. That's in general a challenge that we have when we are comparing experiences and perceptions, or particularly perceptions, just across countries. It's really just, it has to do with the expectation that people may have about this. What we have seen is often the case, they make sense, and we try to be very transparent about the data. But there are a few cases in which just perceptions are way off. One case I remember was in Afghanistan, for example. The police had very positive perception just a couple of years ago when we did the last survey, and this was constant throughout the years, and in part because people often compare the police performance to the time just of the Taliban, for example, just in what there was nothing and so on. So then, but obviously the police in Afghanistan was still very far from what we understand the concept of a good police. So that's a notable example that happened.
Thank you, Alejandro. I have a question for you, which is about the use of ranking countries. So we know, let's say your country performs and comes in at number 48 this year, and nothing's changed, and next year it's also should be 48. But if 5 other countries have improved their systems, then all of a sudden you've slid back. Or conversely, if 5 countries have done worse, all of a sudden you're better, but meanwhile the performance is the same. So we know there's advantages and limitations to this ranking, and can you tell us some of those and why you all chose to do the ranking?
Yeah, thank you, Peggy. So this was, we actually struggled with this decision a few years ago, just on should we rank countries or not, and I'm thinking about all these scenarios. So the solution that we had was the following. So first, when showing rankings, we also show the scores, just to show, for example, precisely the scenario that you're mentioning, that a country may not move in their score, but may change in ranking, and then showing that message, showing, just the country declined, but in reality didn't move, or the other way around, sometimes improved, but declined in ranking, and so on, just to really show that, trying to show an absolute measure just with the scores, but a relative measure with the rankings. So that is the first part. The second part is why to show rankings, and this was, the advantage of having composite indicators is precisely that you can simplify a message just into a number, and really just use that number to rank countries. And actually it took us like a couple of years to come up with the decision of rankings, and really is thinking about who uses the data and how they use it, and what's the leverage that this data may produce. So the information that the index produces, really just the way that it generates, let's say, change, if we think about it, is through 3 ways. Number one is to provide general information to people who are going through countries or navigating just cross-country comparisons, or donors, implementers, and so on, who actually want to know the situation from a country from a big picture perspective. So that's one. The second one is from those who have actually funds. For example, donors is another example, or credit rating agencies. that can use this information and then as a result put some pressure on the country to improve the scores. So either because donors may condition this on some change in rankings, or because credit rating agencies may actually just qualify the country, and that has an impact on the price of debt. So and the third one just is other groups, for example, media, civil society, and so on, that can use this to generate changes in public opinion and generate pressure on governments to change. So then, thinking about the last two, usually for those groups, it's easier to receive the message in terms of rankings. So we know that it's a simple message, and that's why they use it. But at the same time, the reason why we present all the information in a country profile with all of this is because we don't want the message to show simply this is the ranking, that's it, the conversation is over, but to try to open the conversation. And indeed, that's the direction where we're going with the country profiles, with the country reports and so on, to really show the value of the information, to use the ranking simply as an opener for the conversation, but really just move beyond that.
Okay. Thank you. And maybe just to follow up on the question that Pim posed, should the index use additional data to supplement those surveys to create a fuller, richer picture?
Yeah, that's a very good question, and that's something that we have thought about as well. So there are pros and cons of this. So when we developed the index a few years ago, we look at available sources of information and try to actually generate an index with available data sources. And it was very challenging because there was no information available for many of the indicators for many countries. So then, or the information was not comparable. So if we were looking, for example, at information collected by countries, so it was really not comparable, and it was difficult to do that. So then, as a result, we started collecting the information. Now, a few years have passed since then, and then the world is changing. So I think that the SDGs are generating a framework, a very interesting framework for countries to start collecting the information and so on. So that can happen. I mean, just as we move on, I mean, there is just an effort to collect more information. We think that, I mean, the index right now is established and it's comparable over time. So we probably don't want to change it as much in terms of adding new information or new concepts. There are concepts that have arisen in recent years, particularly one example is elections, for example, just the role of social media and so on, just in elections. And that's something that we don't capture because that was an issue that we didn't have a few years ago. So then we decided to leave the index as is, just provide this comparability across time, and that may be something that is valuable. But start just generating these other data collection efforts to show all this richness of all the other information, and that's part of the work that we have been trying to do in the area of civil and criminal justice together with international organizations.
Okay. Thank you. And we have just a couple minutes left. So I'll continue to dominate the conversation if no one else has a question, but I do have one more, and you touched on it briefly, but just to go back to it, Alejandro, political stability can make a big difference in whether a country delivers the rule of law and how. Should this kind of data be included? And I point to the recent change in government in Afghanistan. So you did mention that, but can you take 2 minutes and talk to us about that?
Yeah, we capture it briefly, but first is you're absolutely right. Just this is something that it's fundamental for the rule of law, and indeed the index tries to capture this through a lot of the questions that we have. Just rather than showing the change itself, is showing what the new government is doing with regards to the rule of law. And I mean, you mentioned a very extreme example, but interestingly, the big changes that we see in the index are often when countries have abrupt change in administrations. And by abrupt, I mean, I don't necessarily mean violent, but sometimes when administration changes and the administration is very different from the previous administration, or more populistic administration and so on, that's when we see those some jumps in the scores from one year to the next, that just sometimes they deteriorate or improve over time, but at a more slower rate. So we capture those. I mean, just you're right. I mean, there are probably some elements that tend to vary less over time. For example, the performance of the civil justice system, the criminal justice system, regulation, and so on. I mean, they really require just more of the state apparatus. But some of the indicators related to human rights, some of the indicators related to freedom of the press or checks and balances, they can change and do change actually, when we have these changes in administration. And indeed, just that's something that we have seen over the years, declines in these areas, in part because of many of the more authoritarian or populistic regimes that we have seen in the last few years.
Thank you so much, Alejandro. It's always interesting to hear about the index and take a closer peek behind the scenes, and to understand better how we can use the index and how we should not use the index. So we appreciate very much your time and your thoughts.
Absolutely.
And now we'll move on to our third speaker, Daniel Chen from the World Bank, who's going to talk with us about the judicial program. Daniel, it's all you.
So if I can jump in here, Daniel's still attempting to join the meeting. So, there he is. Great.
Hi, so sorry for running between Zoom and Meet's meetings this morning. So thank you so much all for staying for almost the last session. So I'm Daniel Chen. I'm trained as a lawyer and economist, and I'm part of DJURI, Data and Evidence for Justice Reform, which is at the World Bank. And it's a subunit of DIME, the Impact Evaluation Unit. So DIME's aim is to generate data and research that informs policy and maximize impact. DIME has worked in 60 countries and supported 20 billion in development finance across different sectors. So at DJURI, we focus on the justice sector. So we're a diverse team of lawyers and economists, but also computer scientists. And our broad framework is to work with governments, judiciaries' interest in using administrative data, machine learning, and randomized trials to evaluate the effects of justice reforms that can spur sustainable growth and reduce poverty. Next slide. Here's a map of the countries that we've worked in so far. So these tend to be grouped into 3 categories. In the first group, Chile, Peru, Pakistan, and Kenya work closely with court management, judiciaries, or training academies to design, deploy, and evaluate interventions, often developing the technologies to do so. In a second group, Brazil, Czech Republic, and recently India, we engage with auxiliary actors involved in access to justice, legal search engines, legal analytics, to assess trustworthy AI and its effects, or prisons to assess trust in the law and its effects. And in a third group, where India started, or Croatia, we've obtained the data often laboriously and make historical analyses on judicial efficiency or inconsistencies that can hopefully spur a cycle of change. Next slide. So the reason we can do so is the confluence of 2 factors: the shift from paper trails on the upper left to digital ecosystems on the lower right, and the advent of machine learning tools that can create interpretable data from unstructured data, even predictive models of decision makers to better understand their inconsistencies and now adjust them with digital interfaces. So let me pause here for a half a minute. The usual narrative is backlash to AI in justice systems. So we consider a human-centric approach. So e-justice innovations that promise to speed justice and increase fairness while keeping humans in the loop. So for instance, on the next slide, let me illustrate an exercise of practical or pragmatic empathy. So this is a dashboard that the team developed for conciliation in Peru. So at the bottom of the justice system in developing countries are termed dispute resolution, conciliation, mediation. They're a huge part of the legal ecosystem. And so we initially designed this for managers to see their conciliators' performance, explore the data for patterns in different ways, download reports for emailing conciliators, with the button on the upper left. So for instance, on the right-hand side, you can see data exploration possibilities. Ask the question, are legal centers that take longer duration also less successful because they're less attentive, they're slacking, or maybe the opposite, and they're more attentive and paying more careful attention? Or it turns out you can see a very strong negative relationship. But with the X and the Y, the managers can explore other potential correlational hypotheses, like is it caseload? Or maybe it changes by time period with the bar in the middle, or in the drop-down menus, they can explore geospatial relationships, or they can drill in to specific types of cases, or compare conciliators pairwise, or even ask the successful conciliators to send advice to the less successful ones, who could also in turn ask structured questions. As a management tool, we can also see the causal hypotheses they want to explore, and these can motivate the innovations to study, which often focus on efficiency, such as, next slide, WhatsApp access to virtual courts on the upper left, Uberization of case backlog on the upper right, apps for missing cases on the lower left, or open access legal search engines on the lower right. Or, next slide, the innovations to study focus on training. So personalized case-based teaching, the dashboard shown on the left, or the predict itself, a web form on the right-hand side. So we conceptualize our work to follow the motto, build institutions to help countries generate their own better policies. Next slide. So open source, no code platforms for data entry and decision support on the upper left. Novel survey methodologies to better understand the citizens' or justice needs on the upper right. For people to ask and answer each other's questions on the lower left, or for increasing recognition and respect as we seek to understand our anchors and reference points on the lower right, so we can achieve a more just society. So now on the last slide, let me turn to the entire cycle from data integration to artificial intelligence to causal estimates of innovations, understanding scalable best practices. So in Kenya, we had an earlier project that displays recommendations of how judges can improve a deficient statistic. That is, we give them advice on how to improve. So algorithms had identified the greatest sources of court delays, and we provided this information and accountability on the upper left in the form of one-pagers. And we found on the upper right that it increased the speed of justice. And on the lower left, increased wages. And on the lower right, also spurred structural transformation measured in the form of different economic outcomes. So we're working on expanding the digital footprint in the justice space. So in Kenya in particular, we have a project that we call Cadastre, an ICT platform for mediator and case management. So in the first dashboard, I showed something that was for managers to understand their mediators' performances, to send them reports like this, and to explore causal hypotheses. Well, we're working on different ways of smart assignment of cases to mediators, depending on the counterpart's questions. So in Kenya, they're interested in assigning mediators to cases that maybe are most successfully resolved by certain types of mediators. And that's something that's called adaptive learning or adaptive experimentation. So someone who is performant at a high probability, you might assign the case to that mediator with a greater likelihood while still randomizing to have causal effects. Or in India, they're worried about new mediators who are inexperienced. So we explore concepts around reinforcement learning that is currently more and more used in education. So we think about the optimal sequence of cases that might train the mediators to become successful in the future. So some think of those as fixed, and others think of legal actors as malleable. Another framework altogether is mediators or court actors having private information. So the Legal Uber app is one framework for thinking about how to speed up case backlog in many developed countries. So some courts are extremely congested, some have lots of slack. How do you encourage those to pick up more cases when they have more interest and less opportunity cost of time to take those cases? So we've had many engaging conversations with different countries around the world where they're really excited about the idea that instead of a top-down assignment from a court registrar, we can have a bottom-up self-choice whilst also randomizing to avoid conflicts of interest. So let me stop there. I know I've run out of my 10 minutes, and I'm really eager for the comments and discussions.
Thank you so much, Daniel. You guys are definitely the next wave of measurement in justice matters. So I have to admit that I was a bit puzzled at moments, but I was happy to hear you circle back to the Uberization of case backlog. That's a great example. Can you talk to us a little bit about how the de jure program addresses the problem of the lack of uniformity in justice sector statistics at a global level?
Yeah, so we work closely with operations at the World Bank, many of which are working with different countries to develop data assessments on what's going on the ground in the countries. And we have a framework, this is mostly led by the governance units at the World Bank, to make sure that the assessments are harmonized across the different countries. So we help them in different ways, and as part of these ongoing conversations, one leads to another, where the microdata turns into the macro indicators that then are used in different loan projects to make sure that a project or reform actually does improve that macro indicator down the line. But that's part of the exciting possibilities of the de jure program, is that when you have these conversations with government counterparts and the microdata, they then get excited to explore, oh, these are the things that we think could improve the microdata, and hopefully we will be able to circle back to a future conversation like this and say, across different country settings, we've tried one reform, one smart assignment or other, and these are the ones that seem to work best across different of the macro indicators.
We definitely look forward to that day. Salome has a question.
Hi, my question is about data literacy. First of all, fascinating. This presentation has been really insightful. You mentioned the use of how the managers can then use this information in their work for decision making. So I was interested in, it seems like it assumes a high level of data literacy on the manager's part to be able to use this information and make some conclusions and then action. So do you have any examples of how, what efforts have already been implemented to ensure the use of data for decision making on that level? Thank you.
Sure. Let me see if I can answer that in two different ways. So on one level, the DIME unit in general does a lot of capacity building and workshops around the world to make sure that folks have the best data literacy and causal inference literacy to try to interpret the types of results and reforms that they run into all the time. The other way for me to answer is this graphic on the upper left, which is in a way a testimony to the data literacy on the ground of the courts. And in the accountability treatment arm, this was also sent to the court user committees, a large group of local I wouldn't call it high-level policymakers, but local folks in the different court arenas that had a vested interest to improve case clearance rates in particular. And we can see that there are substantial effects. It does suggest that there is some degree of data literacy and interest. And we definitely made sure that those one-pagers are, you can't really see on that screen, if you magnify it like 300%, that the information that we delivered were as interpretable as possible. So addressing X would increase Y by such and such percent. So it really is kind of like a dialectic between people's understandings on the ground and to make sure that the data dissemination is as sort of perceptible and receivable by folks. But I hope that answers your question. But there's many, many ways to improve data literacy, and just the fact that people have been very excited by some of these apps, these dashboards, is also just an increasing degree of interest in general for data and data journalism.
Thank you, Daniel. This is not my quote. I'm borrowing it, but my current mantra is data literacy is to this century what reading literacy was to the last century. And so we know that in a lot of the countries where we work, people do struggle with data literacy, particularly where they're coming from law schools or business schools, or perhaps not even schools where they've been taught the value. So instituting a culture of valuing data and data use is something that we all struggle with. I see Jay has a hand up. So Jay, you've got a question for us.
Yes, yeah, very fascinating. Thank you, Danielle. I was wondering, I came across an article about judicial bias and how assessments from this program had generated those analysis. Could you describe for a little bit how that type of analysis is done through the system, and like how massive is the database of judicial decisions to determine judicial bias on those instances?
Sure. So the jury team has, as I mentioned at the very top, we have different ways of interacting with our country counterparts. So in Kenya and in India, we had scraped the publicly available data to apply machine learning tools to understand and then try to address issue biases along gender and ethnic lines. So in particular in Kenya, which we can describe in more detail, we analyzed the judges' written judgments to identify slant against women, which measure the extent to which each judge disproportionately associates women with either negative or stereotypical qualities in their writings. And then we associate that judge level slant against women with their rulings on cases that involve women. So that is one way we are, using the sort of the toolkits and sort of research energy on the team to try to study these biases, but then we turn it around to work with Kenya's Judicial Training Institute to try to evaluate the most effective methods to address these biases. So I saw yesterday a project on trainings, and we also have a 18-month relationship with the Peru Judicial Training Academy, which has been eye-opening in many different ways. If I may put on my professor hat for 30 seconds, they were shifting from theory to case-based teaching, and they wanted improvements on how to do case-based teaching. And I said, in this moment of machine learning, what about personalized case-based teaching using the history of their past judgments? So this gives you sort of the multiple actors and dialectic in the World Bank also. Initially, the governance was, well, show us, where does it work? How has it been done before? And we didn't have that conversation. We hadn't developed the tool for that yet. So we said, well, some of the mechanisms behind personalized case-based teaching is self-reflection. Some of the ideas behind social emotional learning. So in the first 12 months, we engaged with social emotional learning exercises with the judges, and we're seeing some intriguing effects. And then in month 13, we started to develop 3 slides ago, the personalized case-based teaching app that has a number of different modalities, and it's exciting. I will mute, otherwise I will start talking about all the different applications. unless it's a leading answer or a question, I can answer that too.
Thank you for that, Daniel. And it's great to see you so excited about this, as are we. Pim, you have a question.
Yeah, I'm curious about the level of objectivity of the algorithms that are being used in the development of the modeling, because I can imagine that for especially analyzing quantitative data, you have already some concepts in mind. Let's say, for the example of backlog of cases, that if you have a lack of judges and you have a high workload of cases, for example, it will automatically result in a backlog of cases. And if you build this model into the algorithm, you get the right answer. So my question is, how objective are these algorithms that are being used for analyzing this data? Are they neutral, or are they a little bit biased because you are including certain theoretical concepts in the model?
So my first response to this important raised concern is that, what is the counterfactual? Meaning, if we start to use algorithms in justice systems, how does it compare to human discretion without any decision support? And if humans are, as well, bandwidth constrained and cognitively distracted, as suggested by the recent book by Sunstein, Kahneman, and co-authors called Noise, then you might actually think even little bits of decision support we need to evaluate prospectively, of course, might reduce the bias that we see on the ground. So A, that's definitely a concern. B, when I mentioned we do a human-centric approach to the gentle introduction of algorithms or decision support, I like to think the predict itself might be a starting point. I'm sorry, this is a little into the behavioral weeds here, but we often might reject the suggestion by a black box computer that says this is a decision or this is an automated information or default. But if it's something that reflects yourself, you might be more willing to sort of think it could be useful, but it's only a default that you can deviate from, and that of course triggers more careful thinking, one hopes, to try to address or ameliorate the potential biases in human discussion. Anyway, all this to say is that these are really important questions. There's an active literature in computer science that's trying to de-bias the models. And as these new methods become more and more readily accessible, our team is ready to try to adopt them as they come. So thanks.
So let me just follow up on that and say, what are the next steps for the de jure program?
Yeah, well, let's see. So the Cadastre project, I mentioned it's thinking about data entry. So up to maybe 2 slides ago, or 1 slide up on the upper left. If you can go back, Josh, or not. Yes, great, thanks. When we started working with some of the government counterparts, we're finding that the original raw data can be in disharmonized Excel files, which of course is very laborious to clean and merge. So we've been working with the Canadian Mediation Committee for an open source data entry and decision support platform that's called Cadastre, which lets them enter and decide what fields they want to have in advance. And then it goes all the way to, who's, the best mediator for certain cases. And then the mediators, this can pivot around to include the modalities, like you have a top-down assignment, or you can have bottom-up selection of cases, like the legal Uber app. So it's kind of like thinking about the integration of a number of these different ideas into a simple no-code platform that I would like to think of as a no-code platform for policymakers to design their own policy learning engines. So the policymakers want to learn more about top-down assignment or bottom-up choice or peer advice giving or stack exchange, for peer group exchange. I think this is what I would like to, hope from the lower right hand on the screen is tools to study how decisions are made to now tools that can improve how decisions are made.
Great. Well, thank you, Daniel. It's been informative, impressive, and we definitely look forward to a wider application of the de jure program's findings and products and services. I want to thank you and our other two presenters as well, Diane and Alejandro, for some very interesting presentations today about harnessing data and for increasing our data literacy. And we will continue striving to do this. So Angela, I will turn it back to you now. And again, thanks to our presenters.
Thanks, Peggy. Well, I'd just like to join Peggy in thanking all the presenters and speakers today for their truly fascinating presentations. I think we've learned a lot. Also, thanks to Peggy for her great moderation, taking us through all these topics in just 90 minutes today. So our appreciation to everyone. As you've just heard, data is a powerful tool in our work. And so now the ABA would very much like some data from you. If you would please take a moment and look over in our chat. We have posted a code to our Mentimeter survey there. The survey will give you an opportunity to give us some feedback on today's event. We would really appreciate your taking the time to complete that while we're wrapping up the session today. We very much want to hear your perspective so we can continue to organize programs that respond to your interests and your feedback. So as you're doing that, like to offer just a few observations about themes that I heard today. First, it's great to see the excitement among this group about data and measurement. I think that bodes well for further discussions and exploration and hopefully collaboration as we all work together to sort of elevate this field. Many of the speakers spoke with us about the importance of standards, improving the quality of data, our ability to interpret and analyze it. I think Diane mentioned the importance of data dictionaries. So all the speakers, I think, in one way or another, flag for us the importance of trying to work with standardized definitions and terms. A second theme, really transformative power of data and big data. Alejandro told us about the challenges and that justice data ecosystems are not only complex, but they're not yet developed. I think Diane highlighted for us the value of developing systems and applying standards, collecting aggregate data across a country, and how that can transform the work of courts. And then Daniel has just given us a glimpse of the revolutionary possibilities when we have that data, how it can strengthen the design of justice sector programs and also our ability to measure those and really fuel the use of technology as well in both dimensions of our work. So important theme. I also heard everyone referring to the role of data in promoting change, promoting transparency, accountability, public trust, how to use it as a lever in our work. Also, a theme, the importance of sharing data, the central role of sharing with each other, incorporating sharing as a priority in the context of programs and in our work with partners internationally. We also heard today about some ways we can share our data. I challenge all of you to think more about that and share your thoughts as part of our discussions in the future on this topic. Also, a theme was the importance of building capacity and literacy, both at the individual and institutional level. So as justice practitioners, also collaborating with stakeholders and beneficiaries to improve capacity and literacy to better enable use of the data and improve measurement. So we hope to continue the discussions we've started today with you in future community of practice sessions, but also over on the JustTrack knowledge portal. We've provided the address for that again in the chat. If you haven't already joined, I encourage you to head over there and sign up. We have the practice notes that were highlighted yesterday, as well as hundreds of documents related to justice sector reform and measurement. There's a place where you can chat with each other. We're eager to see you join us and to share your ideas, share your resources on the portal. So we look forward to continuing to be in touch with all of you, and thank you for taking part today.